This recording is protected by copyright. No part may be reproduced without the prior permission of the University of South Australia.
In perspective, what value contracts can be to companies. So you imagine what the negotiations for that were like. So £164 million, you basically double it and maybe a bit more to get the Australian dollar. So hence the connection to Michael Jackson. So we are moving into 2 weeks of lectures on contracts. This is the last content for your assessment. And remember last week I was saying I didn't think anyone would come to the last lecture. Well, for that reason I've decided not to run it. So we're not going to the pub. So what I'm going to do is actually do a podcast for the last lecture on business dispute resolution, and you can stay home and work on your assessment instead. There'll still be tutes that week because obviously everyone's want to know what's going on with their assessments, but there won't be a lecture on the Wednesday from 7 till 9, so I'm giving you the night off. But if you really want to listen to my dulcet tones, you can listen to the podcast. But as I said, it's not part of the assessment piece. Now, the other thing is I did this lecture on Monday and got through it very quickly. So I think I'm going to just keep going tonight, if you're all okay with that. And I'd say you'll be out of here in about an hour 15. If you're okay with that one, we'll just keep going. Just seem to roll through. And if you've got any questions afterwards, I'll be hanging around if you need the answers. Your assessment piece 1 will be back on, I was aiming for Friday. There's been a couple of hiccups, but it will definitely be back to you by Saturday or Sunday. Sunday at the latest. I even may just start rolling out some classes on Saturday. They're supposed to all be released on the same day, but it's not going to make any difference, I don't think, if some people get it Saturday and some get it Sunday, just to try and get the marks back to you. Overall, they've been very good. There is fails in there, but not as many as we thought there would be, so everyone's done really well. The main issues, and I'm not sure if you're getting feedback from your tutor because they've been marking them, is lack of referencing has been the major issue. You make a bold statement, but you don't tell us why you have to do something or why you're liable to pay Carol penalties. You just say you've got to pay her for her higher duties. So you don't see why, what she covered by. I found the first section's been done the best, the sole trader. The second section's a little bit worse, and then the third section gets worse. Actually, the third section's not too bad. The second section's probably the one that's been the more difficult, the one with staff. But overall, people are getting good marks, so I wouldn't panic yet. If you have failed and you want to come and see me, just email me and I'll fit you in to see you and go through it to make sure you don't fail the next one. It's because the next one's worth much more, obviously. Hence why you should be getting a lot of feedback. If you get your paper back and you want more feedback, seriously see me or see your tutor. Get it so you can improve. That's the idea of getting feedback. You won't get as much feedback on your last assessment because obviously you're not working towards something, but you will get feedback on that. But for a lot of you, it should be really detailed feedback on this, on what you need to do for the next assessment. So in the textbook, we're just looking at chapters 5 and 6 that will cover. We are talking about contracts. So contracts that, how to enforce them, how to create them, what they involve. So chapter 5 and 6 is really your go-to on this. There will be some cases throughout this lecture just to explain different terminology. What you will find with contract cases is they're quite old. Most of them are from the 19th century when the industry was booming in England and then all these things got tested. So you might think, oh my God, they're so old, but they are actually still law today. Just because they were made in 1808 doesn't mean it's not good law in 2015. It's still valid and it's still upheld. Even if it's not written into an act, it's still the valid law here. A lot of law is very old that we still are controlled by under the legal system. So the first thing really is just, the term contract and agreement tend to be interchangeable. and quite often they're using the same thing, but they aren't. Really, the difference between what makes something a contract is, can you enforce it in a court of law? That's the key to it. You know, have you got grounds to say it meets the, all the legalities to be a formal contract? So if you just have an agreement to, if you've got an agreement to come and mow my lawns, that's probably not enforceable because it doesn't meet the requirements, which we're going to work our way through, the requirements of it. So it's just, what promise will be enforced. So if I have a contract to sell you my car for $10,000 and you give me $10,000, I don't give you the car, that's a legally enforceable contract. You can go to court and go, I want that car, I've paid you the money for it. You've breached the contract. And you can either ask, the court will say, well, give her $10,000 back or give her the car and pay the costs or whatever. So that's sort of the difference. So just an agreement is, like, can I borrow your car, is not a contract. So just be aware that it's, it's got to be legally enforceable through the courts, really, not that you'd go to court. Now, contract law is in both common law and statute law. And I used the example last week of murder, and I think that's the best way for you to understand the difference between the two. Remember last week I said, in the Act, the Criminal Law Consolidation Act of South Australia, Section 12 says it is illegal to murder someone, life imprisonment. That's all it says. But we have to go to what we call common law to find out what murder actually is. What do you need to do? I don't know if you remember this from last week. But you go to a case and it says, did I use the example of the guy on the beach last week? No. So if you're on the beach with your mate and you punch him in the face and he passes out and you leave him there and the water comes up and tide comes in and drowns him, is that murder? And so for us to sort of interpret whether that's murder or not, we go to case law. So the obvious one for you guys to understand for murder is I walk up to someone intending to kill them and I stab them. So I do the action of stabbing them in the heart and I intend to kill them. That's pretty clear that what it is, but that actually comes from a case that says you must do an action that kills someone and you must intend to kill someone. So then we go to common law for the beach scenario, which doesn't meet that, does it? You didn't intend to kill your mate. But case law says that actually is murder because you intended to put them in a position of danger, of grievous bodily harm, and the result being that they died. So if you do that, you are guilty of murder. So you can see how we have an act that says a very simple thing, and then we go to cases. And so this is why tonight you'll get cases coming out saying certain things about the way things are advertised, the way contracts are entered into. And legislation obviously controls a lot of contracts. Anything you buy is the Sale of Goods Act that controls those type of contracts. You obviously have consumer contracts, real estate contracts. There's lots and lots of different contracts that you enter into every day. When you catch the train or the bus in here, you are entering a contract. If you drive into the car park across the road, you're entering into a contract by going in there. So contracts just invade every day of your lives, and you probably don't even think about it. How many of you are on Facebook? Not right at the moment, but are on Facebook, or buy things from iTunes? How many of you read the details of your contract? How many of you scroll down and go, I agree? Yeah. You are entering into a contract and you're bound by those clauses, even if you haven't read them. Now, no one reads those. Well, 2% of the world's population probably reads them. I know I don't, and I'm a lawyer. So, how can you be bound by them? Well, you're agreeing to them. You say you've read them. They know you haven't, but they say, you say you have. Or I agree to the terms and conditions of this booking. You do that every time you book an airline flight. You agree to the conditions of your airfare. Do you actually know what the conditions of your airfare are? No. non-refundable, non-changeable, and then you ring up the next day and go, can I change it? And they go, no, and you get all upset. But in fact, you've actually agreed to that. So, as I said, in your lives, contracts are in it every day, doing in lots of different ways. Every piece of clothing you've purchased was a contract to purchase that piece of clothing. Every laptop you've brought, I'm just looking around, all those phones you buy. If you've got a mobile phone, you would have signed pages of a contract, especially if you're on a scheme with Telstra or Optus. And I'm sure you actually didn't read those either in that shop, that they just signed it off. You signed up for 3 years to pay $100 a month or whatever exorbitant amount of money you're paying to get your free texting. So, yeah, there's lots of contracts out there, but also, as I said, we come to common law for some interpretation of legislation that imposes strong standards. And Australia is actually quite famous for having government overreach in our lives. We actually are a very legislated country that very much likes to control. We're probably one of the most over-legislated countries in the world. Compared to America and England, we are incredible. We like to have legislation to tell us how to do everything. So there's a lot of legislation in Australia. It would be, when you talk about government overreach, that's what people are talking about, how they're really controlling your lives because you possibly cannot think for yourself or negotiate for yourself. Has anyone noticed any building site has fences around it? You'll notice when a building goes on now, they've got to have big fences around them. Yeah, because you guys are all so stupid that you might walk on there and hurt yourself. So what they do, they bring legislation in, make you all put fences around, because people can't think for themselves. My favourite one, I'll pause, I'll go off on a tangent here. Don't get me started on drugs. Hey, only because I was a criminal defence lawyer, that's why. If you want my opinion on drugs, come and see me after. So, I will upset people. So, you need 3 things, the minimum 3 things for a valid contract. See, criminal law is much... Okay, that wasn't recorded either. So, the 3 steps you need for a valid contract is there intention? Did we mean to have a contract? Did both parties or all parties in this contract agree to be in a contract? Did we agree what's in this contract? So is there agreement for me to give my car to you, for you to give me $10,000? And the next one is there consideration? So is there some money or something being paid? Now, one of the key things about consideration, it doesn't have to be cash. It doesn't have to be money. The old law says it can be anything. And the famous law line is it can be an acorn, which would show you what year it comes from. So, I could give you a cent for your car, and that's fine. It's consideration. You've given me a car and I've given you 1 cent. So we've actually got consideration. But you must have the 3, the intention, you must have the agreement, and you must have the consideration. So that's a very simple contract, and we're going to work our way through some of the complex elements of these. Well, they're not that complex, but the things that don't go straight forward with the car, me giving you a car for $10,000. So just in summary, these are the 3 things again, just repeated. Is that intention, agreement and consideration? Yep. Intention is that we actually did intend to have a contract. It wasn't just an agreement and a consideration. That we actually were expecting to be legally bound to fulfil this contract. So, sometimes you can say jokes to people. If you go and swim across the Torrens and, I'll run naked down the parklands. That's not a contract, is it? But if I said to you, if you come and do my garden for $100 a week, we obviously have an agreement, we're going to have some money paid, and we've both got an intention to make an agreement there. that's a valid contract. So you've got all three elements coming into it. So there is some things that you need to have before you can even go beyond this. You've got to have legal capacity. In other words, you have to be an adult. Children can't enter into legally binding contracts. And when I say children, I mean people under the age of 18. So if you're 17, you cannot enter a legally binding contract. You obviously can't have certain mental health issues, which in itself is probably controversial. You can't have Alzheimer's. You can't have dementia. So you must actually have what we call legal capacity. The parties have to have consented, which comes back to one of those elements that we spoke about. It can't be illegal. So it can't be for me selling you my drugs. So I can't come to sell you 20 ecstasy tablets for $100 and you try, and I don't give you, let's just say I give you horse tranquilizer instead, which is what's in most ecstasy tablets. You can't sue me for breach of contract because it's an illegal transaction. So, and any form requirement is paperwork, is what we mean, has to be satisfied. So if there's paperwork required, it needs to be completed. If it's not, then it's not valid. And a really good example, and we come to in a later slide, is a real estate contract for the sale of a house. If you haven't got one of those in writing, then it's not a valid contract. So there's three types of contracts, but you can put a line through quasi, because I'm not going to make you think about that. So don't worry about quasi contracts for now. But there's the two main types of contracts are express and implied. So express comes back to when you're talking about, you talk about leases. So when we talk about express, it's when it's written in, it's really clear. There's no question about it. It's written into the contract that, you are going to come and do my garden every week and I'm going to give you $100. Now, if in our contract suddenly you start doing housework for that $100, that's not an express in that contract because it's not written in there. So an express contract is really all the terms are completely agreed in that contract. It doesn't need any clarification of them. They're very clear. But implied contracts are looking at the surrounding circumstances. So if you've been cleaning my house for a year, as well as doing the garden, we can imply there's a new contract there of what you're doing for the $100 a week. So implied just means it doesn't meet written requirements. It's not all clear, but something's been developing and happening that fits it in. So some contracts must be done in writing. So a cheque is a contract. You write a cheque out, you give it to someone, off you go. So anything like that must be in writing. That's pretty old. Cheques, some of you may not even know what cheques are nowadays. It's such an old-fashioned thing. It's going away. If you go to Harvey Norman and you do a hire purchase of a fridge, and I'm going to pay it over 20 months and there's no interest on it, if you pay it every month, that must be in writing. It's comes under the consumer credit code, that it must actually be in writing. You can't just do an agreement with them. And as I mentioned previously, real estate contracts must be in writing. And this is just a case to give you an example of that writing doesn't necessarily have to be like in that Real Estate Institute contract form. These guys were sending faxes backwards and forwards, and then someone reneged on going ahead with the housing contract, and the court said, no, if you put this all together, we form a very clear contract out of this. So if you go on the Real Estate Institute website, you'll find a copy of the real estate contract. Does anyone here lease? We had a couple of people renting last week. You go in, if you go onto those websites that you go to look at, the Office of Consumer and Business Affairs, I think they've changed their name now, but you'll find there's lots of pro formas of contracts and agreements and things like that that they have on there. But your Business South Australia has probably got examples, but the Real Estate Institute would have a copy of their contract and what's in that. But it's not necessarily just has to be that one, although in South Australia you can't sell a house with that under the Act. And here comes your electronic ones that you've all been clicking yes and accepting. So it's the Electronic Transactions Act. This is one you need to look at for your assessment piece, because if you've read your assessment piece, you'll see there's some faxes going, or emails going backwards and forwards for the sale of tables, I think. Not sure. I think it's tables he's selling. You know, and this is how you can use your buy if you do online shopping. I was busy booking accommodation this morning in South Australia, and it was buy. I click on buy, and it takes me in there, and I give them all my details, and I agree to everything with it. Now, electronic, obviously, transactions are the fastest growing ones. Most things now can be done electronically. If you, as I said, if you do any online shopping, you'll be an expert at it. So they've developed it. They're trying to encourage it, which is why this Act's come about, to make them legally binding to where you stand. Don't know if anyone's ever tried to buy something on eBay and then get out of it. It's very, very difficult. I must admit I haven't been on Gumtree, but I imagine that's exactly the same. There's probably binding things in there for you if you bought it. Has anyone bought or sold stuff on Gumtree? I'm sure people have. It's, you know, it's trying to, you are actually entering into a valid contract. So some of the examples from the Electronic Transaction Act is, it's not invalid just because it's happened online. I mean, that goes without saying, really. The information in writing can be satisfied electronically, and electronic signatures are acceptable. So quite often an electronic signature is not you signing your name and cutting and pasting it. It's just different forms of you saying, this is my agreement, this is equivalent of my electronic signature. I use my actual signature a lot on documents, especially when I was a lawyer, and that was considered to be valid because most legal documents now do go via email to the other side and then come back, and everything's got to be signed and initialed and stuff. So if you keep something on your computer, it is equivalent of a hard copy. So if you come across any acts that say you must produce a hard copy, the electronic form is acceptable. And time and place dispatch can be electronically recorded. This is your issue in your assessment. So you need to make sure you're really clear of when those emails went and came back and when they were sent. Did they time in? So as I said, there's got to be an agreement. That's the first thing you've got to have. Now, what is an agreement? An agreement is an offer, an acceptance happening, or conduct. So an offer is someone offering to sell you something, the car, and you're accepting it by saying, yes, I will buy your car and I will give you this money. So I'm making the offer and you're accepting it. So you must have two sides to it. So it's pretty straightforward. There's someone offering and there's someone accepting. Now, I always get my words around the wrong way, so don't worry if you do. But it's a promise by an offeror, OR, to do or not do something if the offeree responds in a manner. So or is the person offering, E is the one replying to say, yes, I accept that offer. I accept your offer of the car for $10,000. So I'll just go to that one and come back. So there it is there. So the agreement is that I've made this offer to you, you've accepted it. Now it can be by conduct. And so depending on what the action is, it can be implied that you've accepted by what you do. And this is the case of Brambles against Bathurst. You don't need to know this for your assessment. I don't think it's in it. But really what happened was the Bathurst Council wanted to do the right thing by waste treatment, and Brambles didn't want. But what happened was Bathurst offered them more money if they did it. You can charge us $1.50 a load if you do this. And Brambles said no, but what did they do? They put their price up by $1.50 a load. And so they started charging the Bathurst City Council this money, but not doing what the Bathurst City Council was. And the court said Brambles had accepted that. By putting that money up, that price up, that was a form of accepting the offer. So that's just doing it from being implied, by the implied action, do it. So an offer. So we're going back to that thing of the first offer, do you want to buy my car for $10,000? That can be verbal, it can be in writing, but the person must know that it's an offer. It's got to be clear and unequivocal to them that I'm willing to sell my car to you for $10,000. So what do you have things you have to do where it starts to get a bit complicated? There's a lot of advertising, and we call this puff advertising. If anyone's doing marketing here, this is where you do something so ridiculous, you make an offer that's so ridiculous that society knows is stupid, and there's no way they're going to respond to it. And of course, America has the case on it, and you can look this advert up on YouTube. If we had a break, I would have played it for you, but I might play it at the end if anyone wants to look at it. So Pepsi did an advert in America where if you collected so many tokens, you got free things. So if you collected, 700, you got a T-shirt. If you collected, 1,500, you got a jacket. And at the end of the advert, they say, if you collect 7 million, we'll give you a Harrier jump jet. And so this idiot did it, didn't he? He paid, as you can see, $700,000 out to get these 7 million points. And then he sued them and said, where's my Harrier jump jet? And of course they refused, so it goes to court in America. And the court said it's clear that it wasn't a serious offer. A reasonable person, and notice that objective. So an objective person, whenever you see objective in anything to do with law, it means the rational, reasonable person. Historically, it's called the man on the omnibus, but it's actually the everyday person. This room is an objective group of people because you're all sort of average, I hate to tell you, from a legal point of view. So would you, when you watch this, know that was a ridiculous offer and wouldn't be fulfilled? No one can really go and buy a Harrier jump jet. And so the court actually found that it was just in jest as puff and advertising. Now one happened last year as well, which was, and I don't know if you read about this or saw it, but it was Red Bull, the drink. So someone sued them because they said, you saying I can have wings, and you say I get more energy from it than coffee. Now, Red Bull actually settled out of court, so we actually don't know what they would have got, what would have happened if it had gone to court. But they obviously decided not to do litigation, but they agreed to pay $13 million US towards this, which was a consumer compensation, and it was a class action. So it'd be interesting to know how much people got. If you put a claim in because you'd brought one Red Bull, would you get your money back? I'm not sure how far 13 million actually goes. And to put in perspective class actions, I'm actually part of a class action in America. I hired a car in Las Vegas, and they put a surcharge on there that has been found was illegal. So they've actually identified everyone that hired cars over this 6-month period, which in Las Vegas would be thousands. And they're doing a class action on it. So if they give them $13 million, I'm probably going to get $10 because there's probably so many of us in it. You know, has anyone here been to Las Vegas and known how busy it is for car hire there? It's hard to get a car to begin with. You know, they'd be hiring out hundreds of cars daily, and if not thousands. So I don't know if anyone else has got one of these class actions. You may have. So it'd be interesting to see when I get my little cheque of $10 through on the class action. But yeah, so Red Bull settled this, and you can actually see that advert, you know, on the internet as well. It wasn't one of the adverts in Australia. It was the advertising some theme called Red Bull Gives You Wings. Have people in marketing looked at it? I'm not sure if anyone's doing marketing, but it's really interesting that it does it. So now we come back to you. When you walk into a shop and you see the clothes on the rack, that is called an invitation to treat. The shop is not offering you that outfit at that price or offering you that drink at that price. They're inviting you to come and make an offer to them to buy it at that price. So in fact, when we come to shops, you are the person making the offer. That is why when you have an item that you know is worth $100 and they've accidentally put a tag on it of 10, you go up to them and say, I'll take this for 10. They go, no, sorry, wrong tag. They're not accepting your offer. Is this clear? So in other words, in all shops, you are the person offering, and the shop is accepting your offer to buy that product for that price. So even if you go into a supermarket, you're still doing the offer of doing that, and the supermarket's going, yep, we accept your offer. So it's called invitation to treat. And I'm not going to read through this. You can read through the case, the Pharmaceutical Society of Great Britain and Boots. This is all tested around pharmacy and what chemists could do and not do with pharmaceuticals, because they were trying to argue that the contract happened when they took a drug off the shelf because the pharmacist was not involved at that stage. The pharmacist was involved at the counter, and they lost because they said the contract's formed at the counter when the customer offers to buy it for that price. So you can see the highlighted bit on there. I'm not sure if you can read that. An ordinary shop, although goods are displayed and it is intended that customers should go and choose what they want, the contract's not completed until the customer, having indicated the articles which he needs, the shopkeeper or someone on his behalf accepts that offer. Then the contract is completed. So it's called invitation to treat. That's how all shops work. Anything retail comes under that. Things like tenders are the same thing. So if you're tendering to buy a building, which is not, quite often you'll see that advert in the paper, in the real estate sections for commercial, invitation to tender for this building. That's actually putting out an invitation to treat. So the tender is the offer to buy the building for $3 or $4 million, whatever it's going to be. And auctions are invitation to treat. If you're at an auction to buy a house or to buy goods in the auction house, you put your hand up, you're making the offer to buy that house at $1 million. If that hammer comes down, that's the acceptance. So it's actually in South Australia the third hammer, if anyone knows auctions very well. For a house, it's got to be on the third. So that is the hammer is the acceptance of the offer. So you can see things aren't necessarily just offer acceptance. And quite often, it's hard to determine when the offer is happening. So in Harvey and Facey, this was some lovely land in Jamaica that they wanted to buy. And what happened is Harvey sends a nice telegram to Facey. You can see the year, it's telegram time. Says, will you sell me that land, which is called Bumper Hill? It says, it actually said, will you sell as Bumper Hill? Telegraph lowest cash price, is what that said. So Mr Facey replies and goes, lowest price for Bumper Hall, £900. Mr Harvey replies and goes, we agree to buy Bumper Hill for the sum of £900, asked by you. Please send us your title deed in order that we may get early possession. Mr Facey says, nah, sorry, that wasn't an offer. And so, of course, it goes to court, and the court says the first telegram was just a request for information. It wasn't an offer. It wasn't anything else. And the second telegram was a response to that information request, and that was not an offer. So the court held up that just this initial communication was not an offer and acceptance. So you've got to actually be very clear in your communication. Now, some adverts, advertising, oh, there you go, there's that, what the case held, was a statement of the minimum price. So some advertising is actually enforceable. So an invitation to treat can be that they say no, but sometimes it actually does. If they ask you to do certain things, you can be held accountable. So the carbolic smoke ball, I think, what year was it? 1893. So good old Mrs. Carlyle, she brought the carbolic smoke ball, and it was designed to prevent users from contracting a cold. And they said, if you provide us with carbolic, said you send us £100. No, sorry, if you buy this, we will give £100 to anybody who follows our instructions on how it's going to be used. And that was 3 times a day for 2 weeks. And if you still got the flu, we're going to give you £100. And in their advert, they said, we're going to put £1,000 in the bank just to show how sincere we are. And there's actually a picture here of what it looks like in 1893. So that was the advert that was in the Illustrated London. So Mrs. Carlyle gets this, and of course, what does she do? She gets the flu, because this was obviously quack medicine. When she said to them, I want my £100, they said, no, that was just puff advertising. So it was like the Harrier jump jet. You know, no one would believe this was true. And the courts said no. It said it was more than puff because you gave someone instructions, clear instructions on what to do. So it's an intention of carbolic to say, if you follow our instructions on this, you will not get the flu. And by putting that £1,000, they show they wanted to be bound by it. So they said it was more than puff. So it was actually basically, you know, putting out there. And then, now, just so you know, at the top of this slide says a thing called ratio decidendi. Don't worry about words like that. We call the things that come out of case law ratio decidendi, and that's just lawyers liking to use Latin still. So it's basically the decision of the court. So an example of Mabo is that native title existed. But lawyers usually just refer to it as ratio. So if you hear us just going ratio this, ratio that, that's what we're talking about. So the ratio out of the carbolic smoke ball is that an offer can be made to the world at large. So we can make an offer to everybody, and we can be bound by it. And you're bound by it by the person doing what you are telling them to do. And they go and do it. And it gives rise to what is referred to as a unilateral contract. So it's a one-way contract until somebody does what they ask you to do. So, for example, if I say to you all, If any of you are the first person to swim the Torrens, I will give you £1,000 or $1,000. That's a unilateral offer out to the world. And I've put my $1,000 in a bank account ready for the first person who's going to swim the Torrens. And someone goes and does it. They've fulfilled the contract. So therefore it is a valid contract and I must give them the $1,000. So it can be enforceable. An option, just finally on offers, if you have an option to keep an offer open, that is a contract within its own right. That's actually, and notice it says here you've got to have a deposit, you've got to have consideration again. So that's just probably a little bit more of information. You don't need to worry too much about options. Now, how do you say no to an offer? Well, how is an offer not accepted? And there's a number of ways. There's obviously saying no. You know, you can just reject it and go, see you later, I'm not going to do it. There's revocation. We'll work our way through a few of these. Lapse of time. If the person dies that's making the offer or the person accepting the offer. Or failure of a condition. So the contract to swim across the Torrens, if no one does it, or if I have a contract with you specifically to say swim across the Torrens and I'll give you $1,000 and you go yes I do and we sign it and you never do it, you failed, haven't you? You haven't met the conditions. So the first one is revocation. So just if I withdraw the offer, it revokes the offer. So if I offer you my car for $10,000 and then I go and say to you, nah, sorry, and you haven't responded to me, I say, no, I've changed my mind, I want to keep my car, I love it, it doesn't happen. You know, the offer's finished. The person you've offered it to, they must be aware that you've taken it back. They can't, you know, you can't just think, oh, I haven't heard from them, I won't do it, because they may come back. So if the person who learns that you're withdrawing it, but from a third party, they can't then go and accept it to try and circumvent and get damages out of you. So if I offer you my car and you haven't heard it from me today, but I've told you that I'm withdrawing it, and you find out and think, oh, I'm going to accept that now because if she doesn't go through it, I can get some money out of her, the courts will not uphold that. So it has to be, that the person knows that we're going to withdraw it and you can't hear it and then circumvent it just for your own benefit. The Bryan and Dixon, as you can see, is a nice old case. Basically, it was about someone wanting to sell some wool to somebody, and it was all about letters going backwards and forwards, and them hearing about different things and not hearing about different things. And they heard that the contract was formed because the communication hadn't been going correctly between the two to revoke it. So a rejection, basically a straightforward no, or a counter offer. As soon as you make a counter offer, the original offer is terminated. It's got to be done again. So I know I'm using my car as a simple one, but hopefully it just keeps it. I offer to sell my car to you for $10,000, you come back and say, I'll give you $8,000. Immediately my offer has gone out the door and you have now made an offer and I have to accept it. And if I go, no, I want $9,000, that $8,000 offer's gone. You're not obligated to it. So as soon as a counter-offer is made, it terminates that original offer. Lapse of time is just, what's a reasonable time to accept something? You can't come back 3 or 4 years later and go, yep, I'll buy your car off you. Obviously, if there's a stipulated time, and death of either party before acceptance will terminate an offer. So you can't go after the estate for it. And failure of a condition is a reason that it won't be fulfilled. Now, if there's a condition precedent, that is a condition before the contract's entered into. So that, I'm just trying to think of an example. If you do this, then we'll agree to this contract. So if you work there for 1 year, then I'll give you a contract for 3 years. So that, and you don't work there for a year, the condition precedent before it has not been fulfilled. Now, are you happy for me to keep going? Just go through it. Now, we're talking about acceptance now. So we've gone through the offer and we're going through the acceptance of the offer. Law can be complicated. So acceptance must be in reliance of the offer. And R.V. Clark is a criminal matter. It was a criminal trial. Matter. So Clark was actually being investigated for murder, but he gave up and gave information to the police about who actually did it. Now, at the time, there was a reward for giving up the information on the of the person who did the murder, and they refused to give it to Clark. So he sued them and said, "This was a contract I fulfilled. You made an offer of, I think it was $10,000 at the time." To give you this information, and the court held no, you weren't accepting the offer when you gave that information up. You were literally giving it up because you were being investigated. At no time did you have in mind that there was a reward. You were basically saving your own arse. And so the court said, it was exclusively given to clear his name, and so there was no acceptance of that offer of $10,000. If there's a acceptance method, it has to be followed. So in this one, the leasee failed to pay rent on time but wanted to renew his lease. And the court said, it couldn't be renewed because you haven't met the condition of the original contract. So even though the landlord didn't ever say anything about irregular payments, it didn't matter. They were still breaching the conditions of the contract. Acceptance must be from someone who can accept it in the company. So a good example, in your burger restaurant, can Carol accept a contractual offer? Because she's not the owner of the business, is she? And the answer is no. It has to be someone who has authority. And the Powell and Lee case was a guy who applied for a job as a headmaster. And he was interviewed by the school board, and the school board decided to give him the job. But they hadn't told him, but he knew someone that was on that school board who said to him, "You've got the job." Then the next day, of course, the school board changed their mind and gave the job to somebody else. So he sued them and said, I applied for that, you offered it to, I offered my services, you accepted them. And they said, the court said, no, that one guy did not have authority to offer you that job, and therefore it wasn't a contract. There was no valid contract. So there was no authorised communication of acceptance. And the other one on acceptance is it can't be silent. You can't say, I will sell you my horse, and if I don't hear from you in 2 weeks, it's all yours. And that was held to be no contract. So silence is not an acceptance. And also, acceptance has to be absolute. It can't be, changed, because as soon as you're changing it, of course, you're doing a counter-offer. So it's straight away that you have to accept it fully as it comes. Otherwise, you're back in negotiation. Now, this is the interesting one with how we start to bring you into maybe your assessment piece. And this is the postal rule. Now, up until 20 years ago, everyone posted everything. Mail was the way you communicated. Not so today. So these postal rules came out of that and how businesses did it. And of course, this is what you've got to compare to the Electronic Transactions Act, because that does give you an example, because it's going to be maybe slightly different to the postal rule, but it hasn't necessarily been decided yet in court. So we've got this postal rule that applies to letters, and we have this electronic transactions and when things are offered and accepted. And you guys have to make a decision on whether that act is so clear that it overrules the postal acceptance rule. So I'll work my way through the postal acceptance rule, get it clear in your head of when it's going to be offers and acceptance. So, an offer by a letter is not effective until it's received by the person. So if I post my letter to you saying, buy my car, I should change it now, what shall I sell you now? You know, buy my, I don't know, Michael Jackson collection for $100, you don't actually, that offer, that acceptance, well, sorry, the offer is not there until you have that letter in your hand. So I post it on the 1st of June, you get it on the 10th of June, that's when the offer's made. So it can be revoked any time in between that on the postal acceptance rule. But when they post that letter back to me going, we accept your offer of $100 for all your Michael Jackson, the acceptance is the day they post it, not the day I receive it. So it's a big difference, okay? So the offer goes to the person on the day they get the letter, the acceptance is when they post their response. So it really is, it doesn't matter if I've posted to them a letter revoking that offer and they've responded to me already. If they get it after that, bad luck. It's been accepted. And Adams and Linsell was really just a bunch of mail going backwards and forwards and getting lost. So, you know, Linsell wrote to Adams saying, we'll sell you this, and they wrote on the 2nd of September. But it got lost in the post and didn't get it until the 5th of September. And Adams replied immediately on that. But in the meantime, they'd posted a letter saying, we revoked that offer, we're selling all the goods, and they did. But the court said no, there was a valid contract because they hadn't had the revocation before they posted the response. So, as I said, this is the example. You know, if you're going to revoke, it's got to get there before they post their reply. That's pretty straightforward. So here comes, by comparison, your instantaneous communications. So there's a case. Now, this is an English case, and it's really, it's been put in here by Rick, but I think it complicates it because you really do want to look at your Electronic Act in Australia. This is complicated. So this case was about electronic communication, and they said the postal rule didn't apply, but the postal rule didn't apply because it was between two countries, not because, you know, acceptance was not accepted then. They said the contract couldn't be formed until the communication had arrived back in England. Now, if we're talking about communication in Australia, we're not talking about two different countries. So I think there's a little bit of a complexity here that I think might confuse you, so don't get confused. But this did say that the postal rule didn't apply to this, but from a legal point of view, we would distinguish it based on that it was two countries, not the same country. So you really do need to know and go and have a good look at this. And as I said, the Electronic Transaction Act provides guidance on times for receipt and dispatch. The Act infers that acceptance could be when the offeree pushes the send button, not when it's received, which makes your life a bit complex in your assessment. So note the infers. So a good lawyer knows that means you go to court and bat it out, you know, depending on who you're acting for. You were saying, well, it doesn't infer that. Notice could is in italics. So this, I can tell you now, I'll take that off, you better fit it. So, the safest legal position, and when we say things like that, we mean it hasn't been decided yet, a court hasn't said. So until you get a situation where there's a huge multi-million-dollar contract that's got an issue and it's worth taking it to court to test it, the safest position is to go with this. But I really would work through, as I said, how this is going to work for you. So that is the bit on offer and acceptance. So let's talk about intention to contract, which is nice and straightforward. It's not that difficult. So it's basically the courts look objectively, and that's, remember, your rational, reasonable person, at whether there was an intention to create a contract, to create the legal relationship. So don't forget you can have an agreement, but a contract is that legal relationship. If anyone does need to go to catch trains, that's fine. So a subject to clause means there's no intention yet to finalise that contract. It's not in its final form. It's still got stuff to be worked through. So the Masters and Cameron one was really just about the sale of a property and the negotiation of the sale of the property. This agreement's made subject to preparing formal paperwork, which was never done. So they said that was, the intention was still not there until that formal paperwork had been done. So there is some implied intentions in contracts, and it's really interesting, and it is changing. It's developing quite rapidly as the society changes between families and money, and how hard it is for you guys to buy property now at a young age, that families are coming much more into a contractual relationship with you. But when they look at objectively, there has actually been two categories the courts have set. And as I said, it is changing this. But the default position is, if it's social, if it's family, if it's voluntary, there's no intention to create a contract. That's the starting point for when they're looking at an implied contract. But if you're in a commercial industry or in business, the presumed intention is to have a contract. So the presumptions start from two completely different points. And they are both, though, looked at objectively. As I said, it's the rational, reasonable person. And you can see from this, that presumption is being weakened daily, yearly, on the social one, because it's coming much more that families are entering into contracts to buy homes and do things like that. If it is a social or family, the person who's claiming that it's a contract, they have that onus of proving that contract. The presumption is that it's not a contract. And it's the vice versa for the other one. It's a strong presumption that the parties intend to create, and the person who wants to claim that it's not a contract, the onus is on them. So that's where that stands. So you've got to have a look at, what was the agreement? What had the parties been doing? What were they, it looks at all that surrounding circumstance. It doesn't necessarily look at form, like what does the paperwork called? or even if the paperwork says this is not a contract, quite often it will be interpreted that it is a contract. And those three, social, family, domestic, just to get it defined for you, social is just between friends and acquaintances, domestic is family, and voluntary is when you're a volunteer working for somebody like, you know, the Country Fire Service or St John's Ambulance. So to give you some examples of some cases, so the social arrangement that can create a contract was the Trevian Grub people. 3 people won a lottery. They'd been paying into it consistently, contributing to it. They won. And obviously one person said, no, I'm not giving you the money. And the court said that was a contract. It could be held to be a contract, give them their share of the money. Domestic situation examples. And you can see the Cohen & Co one's quite an old one. A husband and wife, a promise made while engaged to give her a dress allowance wasn't binding. I presume they did it when they were married because it was Cohen & Cohen. So maybe they were separated. I'm not sure, I haven't actually read the case. And also if there's a de facto relationship that's secret, then that is not binding. And I love this Ashton and Pratt case. If any of you are into following media, you will know who Pratt is. Pratt's was one of the wealthiest men in Australia. And in fact, he always had a mistress. And she actually left him, this mistress, and they had a daughter. And he went to this woman, Miss Ashton, who was a prostitute, and he came to an agreement with her that she would stop being a prostitute, but it wouldn't be a closed relationship. And he would give her $2.5 million and $500,000 annual. If you read this case, it's really interesting. He also gave her a Mercedes car, all this other stuff, like he just set her up in apartments, and of course he dies. So she sues the estate, saying, I want what he promised me, that $2.5 million trust and $500,000. And the court found it was a social agreement and it wasn't binding on the estate. And the reasoning is fantastic, because the reasoning is, what would you sue for breach of contract? It would be for non-performance. So if there's non-performance of this mistress, what's he going to sue her for? Think about it. What condition is not being met? Sex. What damages is there on not getting sex from your mistress? And they said you couldn't put a value on that. So therefore, there was really, no contract, because there's no conditions that could be met or be sued on. So it's a great case to read, how the judges reason it. I can just imagine them over their morning tea discussing it, how they were going to write it. But she lost out on that. So in some cases of families, though, they do find it as a contract. So this guy who asked his sister and her husband to come out from England and look after him, they did. They upped and moved here. After 4 months, they fell out. And they moved out, never spoke to him again for a while. Then he died. Now, part of the promise was if they came out, he would leave his house to them in his will, and he didn't do that. And the court said, no, that was a contract. And the reason they found it was a contract was because these people, this move out here, was actually detrimental to them. It had cost them money. They had changed their lifestyle. They'd done all these things to accommodate this man, so it wasn't really just a social agreement. So it was basically about the position that they were in and what they had done. They put it above just being a social agreement. And the volunteer is that if you're a volunteer, you can't claim workers' compensation. You're not an employee. There's no legal relationship as an employee. employer relationship. And of course, in law, like in everything, as soon as you say that, you find a case that disputes it, and this case disputes it, which was with the Archbishop of this church, who tried to claim long service leave and annual leave, and the courts granted it to him, saying that he was entitled to it despite it not being a commercial relationship, and that he said that there was it. But they did clearly state that wasn't a precedent, so it wasn't binding on any other church. So, as I said, in general, in business and commercial, the courts assume that there is an intention to create legal contractual relationships. But you do have to look at the context of it, and this case here is the one that sort of says they hadn't gone to that contractual part yet. They were still in negotiation because they said this guy didn't intend to give up his intellectual property. And just coming back to our lovely carbolic, money is a strong indicator that a contract is being formed. If there's money involved, you usually have an intention to be bound. Voila, finished. Not bad.